Good morning, everyone. I'm Sam Tiltman, a technology industry expert within Marsh. Welcome to a special joint Marsh and BCLP webcast today, focusing on technology contract risk management. First of all, I'd like to thank all of you, our attendees, for joining and supporting today's session. This morning, we're joined by a highly diverse group of well over 300 people from over 100 different companies, represented across 18 different countries, and over 20 technology industry sectors, ranging from telecoms, the sharing economy, software and IT services, all the way through to AI, data centers, e-commerce, and everything in between. Size-wise, we have a range of companies from startups and PE-backed businesses, all the way through to major publicly listed international technology corporations. If I move on to the next slide, today's webinar is our response to the huge demand from our clients, colleagues, and industry partners. Contract risk affects all of us on this call and represents a major risk category for the tech industry. We are committed to supporting companies in this important area, and today, our panel of experts will focus upon these three key themes. One, contractual risk management. What are the considerations at the point of contracting? Two, litigation trends and issues. What can we learn about tech industry litigation from a risk management perspective? And three, last but not least, technology E&O and cyber insurance considerations. What is insurable and how far can insurance go? If I move on to the next slide, before I begin, I'd like to quickly introduce our panel composed of three legal technology experts from BCLP and one technology E&O cyber insurance expert from Marsh. Marcus Pell heads up the global tech practice within BCLP. We have Helen Armstrong, a senior associate specializing in tech disputes, and Oren Gelb, a partner specializing in data and commercial disputes. And Sarah Neild heads up Marsh's UK cyber, media, and technology E&O practice. If I move on to the Q&A now, we had a lot of demand before this session. Already have over 20 questions. If you look at the bottom, you also have the opportunity to engage in Q&A via some functions on the Zoom webinar, either via chat or the Q&A box. We'll try as much as we can to answer today's questions, but if we do run out of time, we certainly will follow up afterwards. So without further ado, I'd like to hand over to Marcus, who will take you through our first session.
Thanks very much, Sam. I'm very pleased to be wearing a work shirt for the first time for a few months. So I'll kick off and really talk about a few themes around contractual risk management. Just a health warning for all of you. We only have an hour, of course, and each theme in my section, at least, of the presentation merits a lot more focus and attention that I have time to give it here. But I'll tend at least to give an overarching perspective, if I can, as a contracts lawyer, as to some of the issues, both from a legal and business risk angle, that come across our desk when negotiating our deals. My key message really is that it's absolutely critical to understand your company's risk culture, which will influence approach to and management of contract risk from procurement to end of a contract's lifespan. There's no smoking gun. It's impossible, of course, to eliminate all risk through contractual language, but careful identification of risks in the contract drafting, plus understanding the interplay with available insurance cover, is always the best risk mitigation strategy. On to the first slide then, the risk management framework. So what sort of framework are we really talking about here? At its core, in my view, it's best practice to assume a holistic, total company approach, really, that applies a risk framework from the procurement stage all the way through out the contract life cycle. Are the procurement risk processes embedded properly? Other questions that we ask ourselves as to how a company's risk matrix permeates company culture. You can't assume that risk is appropriately addressed if the risk team sits siloed from the rest of the business. How does the contract approvals process work in practice? Make sure that it goes beyond a box ticking exercise and that key stakeholders are involved throughout. Procurement, sales, operational teams, legal, etc., all have a really important role to play. Most large corporates that we see in the tech sector have and should have some form of risk management framework. So Sarah will talk a little bit later about how your risk framework links to the underwriting process. But onto the next theme, which is really about those in the regulated sector. And there are a number of us here who are attending who are in the regulated sector, whether it's regulated by the FCA or otherwise. But there are a few themes from a reg point of view. Being able to demonstrate that you have a robust risk management framework and a culture of valuing risk management is likely to pay dividends in any regulatory investigation. Just a couple of examples I want to give. There's a particular ICO approach that we see here in the UK to data breach management, and my colleague Oren Gale will touch on this a bit shortly around some of the issues around ICO regulatory investigations. And secondly, FCA investigations. The FCA risk controls under CISC 7.1 in particular, impose potential fines for lax systems and controls and a poor risk culture, for instance. Governance. Are there sufficient independent team members to hold people's feet to the fire to ensure that each new project is adequately stress tested before it starts and to offer critical oversight over the project lifecycle? So next slide, please. On principal risks, I'm not going to go through all of these, but this slide gives those commonly reported risks in company accounts for tech-enabled businesses. Focusing on just a few. Performance risk. This is the risk that a company is unable to deliver to scope, or time, or quality, which is very relevant to E&O policies, of course. Regulatory and compliance risks, as I mentioned just before, we're actually seeing a real shift in the allocation of risk from customers to suppliers for regulatory and compliance breaches, for example, for data protection breaches. The mantra that you cannot outsource your regulatory obligations, in my view, is being eroded somewhat. What about tech and business interruption? Well, a couple of points on that. First, disaster recovery and business continuity is becoming a key provision of contracts, as we all know. Even in the last few weeks, we have seen significant disruption to the higher education sector, for instance, that was caused by rogue actors targeting universities, prompting the need to source external security specialists to resolve the problem. Plus, of course, the breaking news item, as most of you would have seen only yesterday. The FCA was successful in its test case against a group of insurers on the scope of their business interruption insurance policies in the context of COVID-19. I'm sure a lot more will be said on this subject in the weeks to come. IP risks. We've moved away really from a discussion about clients wanting to own everything. However, the consequences of that, I think, can be IP lock-in and over-dependence on single suppliers, which can magnify a company's risk exposure. Linked to this, there are complex questions, of course, about the ownership and exploitation of data, and also the need for contractual provisions to permit migration of data from systems at the end of an arrangement, for example, on cloud deals. And finally, on this slide, reputational risks. I just want to say a couple of words on this. A good example, really, of this risk was seen in the very long-running and extremely well-documented case of Bates and the Post Office. While the core of that legal dispute was the Post Office's treatment of their network of sub-postmasters who were responsible for running the branches, it actually resulted from the Post Office's management of its IT deal with Fujitsu. My own personal view is that better project management, perhaps, and oversight of that system, both during the implementation and in the operational phase of the contract, would have prevented significant legal costs, reputational harm, and settlement payments incurred by the Post Office. Next slide, please. You'll see 7 contractual provisions there on the slide, and really what this does is it shows the contractual safety net, as I like to call it, that you really should look to put in place, focusing on key protective provisions. But of course, word of warning, these clauses really will only offer real benefits when contractual performance is poor, or the project encounters difficulties due to external factors, for example, cyber attack or a systems failure or a force majeure, etc. But only if the technical and operational team have been involved to test A, the quality of DR and business continuity planning, and B, the service standards and what the service levels will mean in practice. Nothing here is new. We all know that a key negotiation point is what we do day in, day out in my world is often around remedies for failure to meet contractually agreed service levels, and questions as to whether that leads to credits as a sole remedy or not, or if there is a right to terminate and or contractual damages on top. I will come on to talk a little bit about liability clauses, but before I do so, indemnities is another one that you'll see up there, which is known to all of us, and the basic legal position really is that an indemnity gives you pound for pound recovery, and the rules on remoteness and mitigation of loss do not apply. Claims under an indemnity are therefore treated as debt claims. But if you are giving an indemnity, just make sure that it's very carefully limited in scope and consider your caps and exclusions very carefully. For example, whether it should include third-party claims. One thing that's not on your slide, but I thought it's worth flagging here, is around termination. It's worth noting the new Corporate Insolvency and Governance Act 2020 that was passed during COVID. This is really interesting because it's brought in certain limits on a supplier's right to terminate its contracts with customers in financial distress. We don't have time, unfortunately, to talk about these developments in detail in this talk, but just note that suppliers now face increased risk where they're effectively unable to terminate certain customer contracts with customers in certain insolvency procedures because of the ban of what we call ipso facto termination clauses. Next slide, please. Liability. Well, you'll be very pleased to know that, that I won't go through in detail all of these different limbs, and I'm sure you don't need me to tell you that careful review of liability provisions is absolutely key from a risk perspective. But just a few words on this. Just from a trends perspective, what we're seeing is that much more restricted liability provisions, particularly in cloud and payment service arrangements and telecom contracts, for example. For these types of contracts, I always ask myself, is there a standardized approach that the procurement team could adopt for our clients? Can you make use of playbooks for certain types of contracts? I'm sure you're all looking at those sorts of questions. We're tending, in terms of sort of liability caps, we're tending to see super caps more often, which limit liability, as you can see from the slide, particularly by way of an example in respect of personal data, and personal being key, personal data protection breaches and exit assistance breaches. One word on unlimited liability. As a lot of us know, this still applies to certain types of loss, but with a twist. For example, for data security breaches, we're tending to see that suppliers like to carve out their liability and often manage to win these points in the negotiation for particularly for personal data breaches, which, as we said just before, normally subject to a super cap, as I've just said. Liability caps are, of course, an underwriting issue and depends very much on supply insurance cover. Just a couple of words on exclusions. We see suppliers excluding liability for economic losses, as well as the types of losses categorized as indirect losses. However, an exclusion of indirect or consequential loss may not actually give much protection, interestingly, against certain types of financial losses. The question really is whether the financial loss suffered is of a type that you would normally expect from the breach. And finally, before I close and give some thoughts on by way of conclusion, just think about your insurance cover. And the one case that I will mention here is the Ampleforth case. The issue considered here was whether or not a professional consultant's cap on liability was enforceable. The court said that the liability cap may be unreasonable if it is far below the amount of professional indemnity insurance that was required under the professional appointment. Finally, by way of conclusion on the next slide, contract management really is not just about contracts, particularly at this time in the economic cycle. I just want to leave you with 4 main points. 1, given the current economic volatility that we're seeing and the uncertainties following the repercussions of COVID-19, and of course, the uncertainties of Brexit, it's more important than ever that all proposed technology investments are validated internally, both before and during the procurement process. 2, when negotiating a contract, just check whether it has a robust exit management plan, and once the deal is signed, whether this has been road tested operationally and kept up to date over the contract lifespan? 3, with the likely continued remote working environment that we're all seeing, how do you manage risks of a remote workforce and the challenges in maintaining business continuity? Just check that your systems support that over the long term. There are all sorts of challenges, of course, around information security and the remote workforce, which really merits a whole discussion in itself. And finally, in respect of trends in AI and big data, do you have the right people who are able to interrogate the evidence for using these technologies in your business? Can you be sure that you can avoid bias in your use of algorithms, crunching big data sets? No business would want an off-call A-levels algorithm type disaster that we saw in the summer. I'm now going to pass over to Helen, who will talk about litigation trends and issues in this context.
Thanks, Marcus. So you've signed the contract and hopefully the terms have minimised your risk as much as possible. What next? Oren and I will be discussing litigation trends in the tech and cyber space, picking out key recent court judgments and identifying the areas in which hopefully you can minimise your legal risk during the lifetime of the contract. So what are we trying to achieve when we talk about minimising risk? Next slide, please. The main objectives for us as lawyers are ensuring that our clients avoid a breach. This is both a breach of the contract and also wider breaches such as legislation, for example, data legislation, which Oren will come on to later. It's also about avoiding a dispute, not just about a breach. It could be a dispute about the contractual terms, the scope of services under a contract, or the fees to be paid. It's also about limiting liability if a breach does occur and limiting your costs if a dispute does arise. I think the one key takeaway that I want you all to remember, if you don't remember anything else other than that, is that don't put the contract in a drawer after you've signed it. It's really important that you keep coming back to the contract to check that you're complying with the obligations, and if there is a dispute that's arisen, that you're ensuring that you protect yourself in accordance with the terms of the contract. So in my experience, there are 4 key reasons why disputes tend to arise in tech projects, and they're listed on this slide. The first one is a failure to understand the key challenges during the negotiations and to properly document those in the contract itself. The second one is a failure to allocate the risk in the contract. Now, I think these 2 points really go hand in hand. It's all about ensuring that the contract is clear and ensuring that it's workable in practice. The third one is a failure to implement formal changes during the lifetime of the contract. For example, where things have shifted in practice, making sure that the contract is changed to reflect the practice in reality. And fourthly, a failure to escalate disputes early. I'm now going to talk about these 4 areas in slightly more detail by reference to the case law that's come out recently. The first point is clear contractual allocation of risk. Next slide, please, Rob. The key case in this area is Royal Devon and Exeter NHS Trust and Atos. Now, in this case, it involved a 5-year project for the implementation of an electronic patient record system at the Royal Devon and Exeter NHS Trust. It involved the rollout of the developed solution in 2 departments in the first year, and then for the following 4 years, there would be the rollout for the rest of the 47 departments at the NHS Trust. The question of liability arose after the Trust claimed that Atos had breached the contract. The court had to look very carefully at the clause that's on this slide, limitation of liability. This stated that the aggregate liability of the contractor should not exceed, for any claim arising in the first 12 months of the term of the contract, the total contract price, which was actually 5 million. And for claims arising after the first 12 months of the contract, the total contract charges paid in the 12 months prior to the date of the claim. And that averaged out at roughly £500,000. So it was a big difference as to which limitation of liability applied. The question that was asked was, in essence, did the parties intend only one cap? So for any breaches arising, whether they were in if a breach arose in the first 12 months, was it the £5 million cap, regardless of whether breaches arose during the rest of the term of the contract? Or did they mean that if a breach arose in the first 12 months, there was a £5 million liability, but if a further breach arose later in the contract, that there would be another £500,000 liability? So Rob, I think it'd be useful just to run a poll now to see what people think, whether this clause intends to implement one cap of liability or two caps. In essence, the court decided at the High Court that it was a single cap, i.e. the parties only intended Atos to be liable for the total contract price, regardless of how many breaches and when they occurred. The Court of Appeal, however, on appeal, determined that there were two caps, and their wording was that this was the meaning which led to the least bizarre consequences. In essence, the court held that the commercial position was that the contractor shouldn't get away on a free ride for years 2 to 5 just because it had breached the contract in the first year. And this case really shows why it's difficult to interpret a clause and why the parties should consider very carefully the wording that they include in the contract. Moving on, the next trend that I wanted to raise was the implication of an obligation of good faith in relational contracts. As you can see, there's two recent cases on this. The Bates and Post Office case, which Marcus mentioned earlier, held, in essence, that there was an obligation of good faith under the contract between Bates and the Post Office. The court, however, held that it was only in relational contracts, i.e. these are long-term contracts where the parties' roles to be performed with integrity and with fidelity to the bargain, where it wasn't always possible to express all of their obligations exhaustively in a written contract, and where there were no express terms in the contract that prevented such a duty of good faith being implied. So, for example, if you have an IT outsourcing contract that's long-term, it may well be that the court implies an obligation of good faith into such contract. The UBB was a good example of a long-term contract. This was a 25-year contract for the construction and operation of a waste plant, and the court held that it was indeed a relational contract and there was an obligation of good faith. So you should just be aware that even if your contract doesn't expressly include an obligation of good faith, one may well be implied by the court. Moving on, another area where disputes often arise is where there's been a change to the contract in practice. So, for example, the scope of the services have changed. And the parties have agreed orally to change the way that the contract has been implemented. But they may, for some reason, or for example, because they've forgotten to do it, have amended the contract formally in writing to ensure that that change in the implementation is set out in the written contract. Now, where a contract states that there is an obligation to vary the contract in writing, there's been disagreement in the courts to date as to whether an oral variation is sufficient. Rock Advertising and MWB is the key case on this. In the High Court, they held that an oral agreement wouldn't override the written contract. The Court of Appeal actually overturned this decision and held that the parties were free to make oral modifications, even if the contract stated that any variation should be in writing. And then this case went all the way to the Supreme Court, and they in fact overturned the Court of Appeal decision in favour of certainty, and held that any oral modification wouldn't be effective if the contract stated that any variation should be in writing. So I just wanted to flag that this can create difficulties in practice. It's important to make the business aware of this, to make account teams aware of the fact that oral agreements may not be sufficient to override and vary the original written contract. In practice, there is a balance to be had between protecting your legal position on the one hand and being flexible on the other. So if we click to the next slide, it's often about weighing up commercial risk and the commercial risk of not implementing a formal change. For example, how costly is the work being contemplated in a change, for example, to functionality? How likely is the other side to dispute the change in future? And do you have any commercial leverage with which to enforce the change, even if you don't have a strict legal right to enforce the change in the contract? And just as a practical point, always try and get written confirmation of changes, even if you can't use the formal change process in the contract. And finally, I just wanted to move on to early dispute resolution. One point to note is to always comply with the contractual dispute resolution procedure, for example, formal notices of disputes, mediation, etc. One recent case was Open and Invesco, a case on which I acted for the claimant. The contract clearly stated that the parties had to mediate if any disputes arose during the development and implementation phase of the project. But in this case, the contract had actually been terminated. So the claimant argued that there was no obligation to mediate. While I think the contract, there was no obligation under the contract, although I would say that because I acted for the claimant, the court nonetheless interpreted the contract as requiring the parties to mediate, and they emphasised that there was a public policy interest in ensuring that parties tried to resolve disputes without referring them to court. I just wanted to point out that that was particularly relevant in the current circumstances because the government has issued guidance during COVID that parties should try and resolve disputes without rushing to the courts for a formal judgment. So just some final practical considerations in raising disputes early. I wanted to point out that acknowledging a dispute simply means that that dispute can be resolved. It's not necessarily an indication that there's a bad working relationship. In fact, there's a good working relationship if the parties can work together to resolve it early. It can also be very helpful in minimising the losses that may be incurred as a result of a dispute long term. So that's all that I had to say, but I'm now going to pass over to Oren, who's going to discuss some of the key litigation trends in the cyberspace.
Thank you, Helen. Good morning, everyone. Hopefully I'm off mute. Thank you, Helen, for giving me that reminder. Otherwise, I'm sure I would have made the same mistake. So as Helen said, I'm going to talk a little bit about continuing that scary theme of litigation, but particularly focusing on data and cyber. What we've got up on the screen at the moment is the latest survey from the government's Department for Digital Culture, Media and Sports. And it confirms really what we are seeing ourselves in practice. Still the kind of most common types of cyber attack originate from phishing emails. And that really covers number one and number two. So what do I mean by phishing emails? An email you get in that sort of directs you to a fraudulent website, or it's impersonating someone. Increasingly, I'm tending to see some of the emails come in that suggest some of your emails have gone to a spam or a hold folder and you need to give in your password in order to get them released. They look really authentic, they increasingly look authentic. So, but that's still the biggest source of cyber attacks. And actually in COVID times, we've heard anecdotally that this has got even more common, possibly reflecting the fact that so many of us are working from home, working on our own devices, possibly giving rise to further vulnerabilities that can be exploited. So what are these kind of bad actors doing when they get the credentials and they gain access to the system? Often they're sitting there, they're observing, they're waiting, they're seeing if they can see any wire transfer information or an opportunity to sort of intercept an invoice, and essentially they're looking increasingly to benefit and take away money from the organization. And that kind of issue, it really is theft of money, and Sarah will be able to speak to this much more authoritatively than I, but often that's not really a cyber policy issue so much as a crime insurance policy issue. And sometimes I've seen insurance policies require certain conditions before you can claim for that kind of theft. For example, have you got multi-factor authentication set up and that sort of thing. The other point to note when this type of thing happens is you're not just looking at, have I lost money and do I need to recover? You're also looking at what data has been accessed by the bad actor. Is it sensitive data? Is it personal data? That can inform your reporting obligations, both to the data subjects, to the ICO, to any other regulator. And that can be quite a minefield to piece that together and use forensic experts to work all that out. So it's a real headache. If we go into the next slide, Rob. So this slide, I'm not going to go into the details of the case, a CMOC sales case, but really what I want to say on this slide is the courts are trying to be a bit more creative when firms suffer this type of fraud. In this case, the court allowed the claimant, who was a firm that basically lost 6.9 million through wire transfer fraud through basically a bad actor gaining access to the CEO's emails and systems. The court allowed the claimant firm to issue a claim against persons unknown and to apply for a freezing injunction against persons unknown. Why does it need to do against persons unknown? Because ultimately it has no idea who's perpetrated this fraud. It has no idea where the money's ended up. So it's got to issue a claim against someone. So it goes against persons unknown. The court was also kind of priding itself on how modern it was by allowing the court documents to be served by Facebook Messenger, by WhatsApp, in a virtual data room. So the court was trying to sort of bend over backwards to allow the company to find a way to get through, to get through and try and ultimately find where the money is. So it would issue this claim. It would then seek disclosure orders against banks, follow that through, and through this intricate web of where the money ended up. The reality is, yes, courts are being more creative, but it is invariably very difficult. And by the time you found out where the money has gone, if you've ever found it out, that money is dissipated. So it's very, very difficult. I did ask the lawyers acting for CMOC whether more money had been spent on legal fees than actually had been recovered in this case, to which I got a no comment. So read into that what you will. But yeah, it can be difficult and expensive to get any recovery. Rob, on to the next slide, please. Thank you. So I want to talk a little bit, another trend in litigation is in relation to sort of group actions. Now, when the GDPR came out, there was a lot of headlines about 20 million fines, 4% of global turnover, and that's all true, and that's all scary enough in its own right. But sometimes the exposure can be even more when it comes to actual group litigation. A bit of context for you. This country, the UK is not really the US in terms of, we don't have that class action culture that they do in the US. And most people will say that's a good thing. Even myself as a litigator, I'd say that's a good thing. We don't have such a litigious culture that there's class actions left, right, and center. However, the landscape is changing, and increasingly we have seen more and more group actions. It started off particularly in the competition space because there are rules about group actions in antitrust breaches. We've seen them in the sort of big consumer claims. You think of the Volkswagen emissions scandal. We've seen them in investor claims. You think against RBS, against Lloyd's. And data breaches, many people think that's the next big wave of these big class actions. The most significant issue in weighing up a firm's exposure is, could it be an opt-out claim or could it be an opt-in claim? What do I mean by that? Just as it sounds, an opt-out claim is where every member of the group, every member of the class participates except those who actively opt out. An opt-in claim, by contrast, every member of the group has to actively opt in at the start and into the claim. Now that sounds like a bit of a kind of procedural point. Is that really, so significant? That can be a real game changer when it comes to the potential exposure for an organization. Because we know statistically that people don't tend to opt in. If you think of an example of the Morrison's case, I might come on to that shortly if we have time, but they're a disgruntled employee published on a website details of 100,000 Morrison's employees. There was a claim and only 5,500 employees opted in. So had Morrison's lost that case, they would have only been exposed to that 5.5 damages for those 5,500 claimants as opposed to the 100,000 whose details were published. So it really can make a big difference. What's happened, I can't really kind of talk about kind of data litigation without really mentioning the Google case, because that's really been a significant development when it comes to this opt-out process. We do have an opt-out process. It's under CPR 19. It's a representative action. we've had it for a while. Frankly, it's been quite a dormant process. Not many claims have got off the ground under that rule. And the reason is because every member of the class has to have the same interest in the claim. And that's been interpreted quite restrictively until we got this Google case come along. Quite simple facts, about 4 million iPhone users, and Google tracked those iPhone users, tracked their internet browsing activity, and then used that data for its own profitable purposes, sold it to advertisers. Does every iPhone user have the same interest in that claim? Because they all browse the internet to different extents. They all look at different sites. Some might look at very embarrassing sites. They not want that data published. Some might look at, perfectly or less embarrassing sites. Some might be happy to get targeted adverts, and some might find it a bit annoying. So everyone kind of has a different impact. But what the Court of Appeal said in Google, overturning the High Court, is yes, there might be a different impact, but everyone suffers the same basic type of loss, a loss of control of their data. That has value. Data has value. If you lose control of it, you lose an asset of value. And so the key question is, what is that value? What's that worth? We're some way from finding that out. It's going to go to the Supreme Court. We're still in an early stage of the case anyway. But the claimant has put forward a figure of £750 per claimant. And that doesn't sound much, but you do the maths and you multiply by 4 million iPhone users, that's exposure for Google of £3 billion. So it just shows you how powerful these opt-out claims can be. There was a sort of lifeline for firms in the judgment of the Court of Appeal, which said, look, we're not going to expose to damages in trivial cases. So that's going to be a real sort of battleground in the future. Is it a trivial case? The court said, if you've got a data breach, it's one-off, it's very quickly remedied, that's trivial. We're not going to let damages accrue for something like that. So that, as I said, that will be a battleground in the future. Rob, can we go to the next slide? Just very quickly, I'm conscious of time because I want to make sure Sarah has an opportunity to speak about the insurance, but there have been a couple of key cases from the Supreme Court in the area of vicarious liability. I mentioned Morrison's already. Essentially, what do I mean by vicarious liability? Just very briefly, where a firm is held strictly liable for the wrongdoing of its employees. In Morrison's, it was held that the disgruntled employee, the Supreme Court confirmed that the disgruntled employee shouldn't render Morrison's liable. What that disgruntled employee did wasn't sufficiently closely connected to his employment at Morrison's. Barclays' case confirmed that an independent contractor can't render a firm vicariously liable. In that case, Barclays used a medical practitioner to give a medical examination to new employees, and that medical practitioner sexually abused a number of new employees, but Barclays wasn't held vicariously liable for that. So organisations have welcomed this case both these cases in terms of putting some limits on vicarious liability. And then Rob, just final slide there is just kind of wrapping up some of the sort of points both Helen and I have kind of cantered through already. The slide is sort of anti-clockwise, the numbers start one on the left and go anti-clockwise. But yes, there needs to be some recognition that parties need to be able to act flexibly. But in English law, as Helen said earlier, contract is king. The terms of the contract. If you're trying to argue that there's an implied term, or you've got a duty of good faith, or you're starting already from a difficult position. The terms of the contract are king, so be aware of them at all times. And yes, there could be issues arise. I mean, frankly, it could be inevitable in a long-term contract. It could be inevitable. There's going to be some potential disputes. Have an early dialogue, escalate them early, involve legal, and as if this was planned, our sixth point there is make sure you notify insurers as soon as the dispute arises, which is a nice segue onto Sarah to talk about cyber and cyber and E&O policies.
Thank you, Oren, very much, and Helen. So why buy insurance? Obviously, we're talking a lot today about the contractual side of risk, but that isn't the only reason. I mean, obviously, first and foremost, like any insurance, it's there to protect you against that catastrophic financial loss when it all goes horribly wrong. And from a liability perspective, obviously, when you look at your contracts, those caps can be very clear, or not potentially, if you listen to the things Helen has warned you of. But the litigation that goes along with this can also be really significant. And so a policy that can sit beside you and help run that litigation with you, that leads to help the defence of your reputation when you're in court. Sort of two sides of the same sign around this contractual piece. In the tendering process, it can provide a competitive advantage when you are required to evidence cover. I have one client in particular who works in a very niche space, who over the years has developed a very high limit of indemnity because it makes it very difficult for anybody else to unseat them, because it's unlikely they will be holding that much insurance. And for the client they work for, that's seen as a really valuable protection. So there's the pre piece in the tender where you are showing a competitive advantage, and then obviously once you win, there will be a contractual requirement within it, usually to evidence insurance. But outside of those contracts, there are other issues to consider. So competitor claims, for example, they're not subject to any contract. So any kind of dispute around IP infringement on software, for example, would still be picked up by a technology policy because it relates to your delivery of professional services, but it's not governed by any kind of contract or cap. And the same goes for any other claims outside of privity. So if you think about claims arising from clients of your client, they would not be bound by any contractual cap that you have within your original contract. So moving on from there to the next slide, please, Rob. Aside from the contractual limit you're required to buy, there may be a delta between the contractual limit you evidence and the actual limit of liability you've accepted under that contract. So state and foreign governments are a really good example. If you want to work with them, 9 times out of 10, they will not allow you to cap your liability. And so policies can be there to help you protect that unknown amount. Even when caps are there, as Helen has highlighted, will they be enforceable 100% of the time? Have you accidentally crept the scope of your project to bring in work that's not actually governed by the contract anymore and therefore falls outside and would not have the benefit of these contractual caps? So that's what E&O is there for, really, to help pick up those things. So what's actually insurable under an E&O policy? Moving on, Rob. Not all of the liability you accept under the contract can be picked up under the policy. And I've just tried to highlight some issues here to think about when you're accepting responsibility for these things. And there's a big cluster of items in that middle section for partially insurable. Accepting responsibility for fraud and dishonesty. Policies are not there to pick up deliberate acts. You will find that Techiano policies generally carry fraud and dishonesty exclusions. You should look to carve these back as much as you can to just the fraud and dishonesty of senior members at board level, and only where it's proven, so that you still have the benefit of this cover, in particular for the defence costs and for other members of the firm who are not involved in the particular fraud. Contractual fines and penalties. These are in essence liquidated damages. So items that you've accepted that go beyond your strict legal liability. The policy isn't going to pick those up. We can temper the language so that where you have accepted a liquidated damage, which is a little bit more than would have existed, we can look for the policy to indemnify you up to the amount that you would have been liable for without the agreement to these fines and penalties. Similarly, for credits and refunds, a lot of tech disputes get resolved through commercial agreements which involve credits and refunds, which are very, very difficult to tie back to what your legal liability would have been if we look at the dispute from the strict eyes of the law. Punitive and exemplary damages, they're not insurable in all areas. In certain states in the US they are, but not others. And so they could only be partially insurable. And then data privacy fines and penalties. We've all discussed lots of times what would happen with the GDPR fine. It's still unclear. What do policies say? Policies say they will pay these fines and penalties where they are insurable at law. Are they insurable at law? We don't know the answer. We are waiting for precedent. And I can see Oren smiling and hoping that I don't ask him that question, which I'm not going to. We don't know. We need somebody, hopefully not in the audience today, to be insured, suffer a fine, and then we will know. In the uninsurable field, project delay. So we mean pure project delay here, not for any underlying negligent cause or breach of duty. It's just slow. Everybody's had a bit of a Friday afternoon effort about it. The policy isn't going to pick that up. Technology E&O is exactly that. There has to be some kind of error, omission, breach of duty, some kind of underlying issue that has given rise to the delay. That's fine. Just too slow, not covered. Similarly, contractual guarantees. If you are guaranteeing something, warranting something in your contract that goes beyond the usual standard and duty of care that would have existed, the policy will not cover that either. So think about the language that you're using when you're setting your SLA targets, put for these clients and avoid the use of those two words. There's one little item in the insurable side, and that's loss mitigation. Now, these aren't things that you accept under contract. This is more an issue for you because, as I've mentioned, we see lots of technology, claims really dealt with at that commercial initial stage. And that often will involve you doing rework or sinking some extra expense and cost into that. And so Techiano policies can be extended to include that extra work that you do to help mitigate a much bigger loss down the line. So if we thought about why would we buy it and what's possibly covered, how much do you need to buy? Which is a bit of a how long is a piece of string. I mean, obviously risk exposure always plays a part. If you are a very large IT company providing transformational solutions for major multinationals, your risk exposure is much, much higher than an IT company selling pre-packaged software off the shelf. And so, that's always been a driver, along with individual companies' risk finance philosophy and how much you're prepared to take onto your balance sheet. What we have seen as a trend in recent months with the hardening of the insurance market really as a whole, but we are seeing it particularly within Techiano, is that when reaching a decision on how much insurance to buy, clients are very focused on their actual contractual requirements and what their budget is. It's all very well having a philosophical idea of your overall risk exposure, but with insurance rates going up, budgets are not endless, particularly in the current economic environment. And so, we do see clients looking back through to really understand what do our contractual requirements say? How many contracts have we got where we have accepted unlimited liability? What is our standard cap? How often are we hitting that? How many outliers have we got? Because sometimes, we've sort of got clients a lot of years down the line who have accepted a very high contractual requirement for a limit far beyond anything that's in any of their contracts. And they're still buying that 6, 7, 8 years later just to meet that contractual requirement. You move on to the next one, please, Rob. So what do contracts demand? It's a very little box on the left, but it sort of covers most of what I want to talk about for the rest of my slot, really. We see lots of queries from clients who are being asked to evidence professional indemnity, PI, errors and omissions, technology errors and omissions. It's all the same thing, it's just a different name. Doesn't change the coverage particularly, it's not a specific thing. But what we also now see are clients being asked to evidence cyber, which is a very different cover to technology E&O. And often what we're seeing is that our tech clients are seeing their clients thinking about what the consequences are for them of a loss. So, a failure of the tech provider leads to a business interruption for the client or leads to some need to notify the ICO of a breach to the client. And so they're thinking about how those are covered under a cyber policy and expecting tech clients to carry a cyber policy that covers those risks. And of course, that's not really how it works. Your client suffers a data breach or a business interruption because of some kind of failure in your delivery of services. That's a technology E&O risk because it's a breach of professional services. Your cyber policy is not going to help you because cyber policy covers you directly. And I'm going to cover that off a little bit more in the next slide. But beyond that, what do we see evidenced, the most regular points of contention? Limits of insurance. We do see clients, customers looking to push up those limits, ask them to be evidenced on an any one claim basis, which is virtually impossible to achieve in the commercial insurance market currently. It is much more an aggregate type risk. We are also seeing pressure for clients to agree to certain standards around the security rating of the insurers that they're using. What I would say here is it's much easier to accept a specific insurer rating requirement in the contract, albeit you obviously have to monitor it, than somewhat vague terms such as, an insurer acceptable to the client, an insurer of good standing. These things are pretty vague. If you're in a dispute, they're quite hard to evidence. So, maybe think about tightening that down a little bit. The last thing that we see a lot of currently are clients, customers asking to be named as additional insureds on these policies. It isn't really relevant unless you're acting as a subcontractor to these people, and therefore they could be sued directly for things that you have done wrong. What people seem to think an additional insured endorsement does is gives the customer direct access to a policy, and it doesn't. However, it seems to be increasingly difficult to negotiate out of that. It's very much a tick box item on the agenda. And so we are seeing increasingly technology underwriters agreeing to add these additional insured endorsements just to help you from a contractual process. So last item, please, Rob. is just to think a little bit more about Techiano and Cyber and how they overlap and what you're actually being asked to evidence. So, you know, Cyber was sort of born out of the Techiano market, so there is some overlap. But if you think about it in terms of broad buckets, so, you know, your Techiano policy is going to cover you for your liability to third parties arising out of the delivery of your professional services. So that includes all the breach of contract and duty and negligent items that I've included, but it also includes your liability for privacy breaches and the transmission of malware. And that's where the overlap with the cyber policy sits, because they also have direct insurance clauses that cover that. The difference is the cyber then also includes a number of first party covers, such as business interruption, notification expenses, forensic expenses, all the things your customers will suffer as a consequence of your breach of duty. So in contracts, customers are increasingly asking for you to cover cyber because they're thinking about business interruption and notification, but actually that's simply a financial damage they suffer because of your breach of duty, which tips it into the Techiano. Now, you know, sometimes our clients can push back on this. It depends very much who you're dealing with in the legal team on the other side. For some of them, they have no understanding of insurance, and why would they? And they simply look for it to be agreed and ticked and assume that it's there. And so, you know, increasingly clients, you know, in fact, almost all of my clients are buying a Techiano and Cyber blended policy, not just in consideration of their cyber risk, but also to help with this contracting process. And that, in a nutshell, are the trends in Techiano and cyber insurance. So I will hand back to Sam to deal with any Q&As.
Thank you, Sarah. We had a large number of submitted pre-questions before this event, actually over 20. There's been a couple today. Hopefully we addressed a lot of these themes. We did adjust some of our content last week. Unfortunately, just looking at time and where of your diaries, we run out of time today to respond to the much more specific and technical questions. However, what I can confirm is we'd be more than delighted to provide a written follow-up. Some of these areas are quite technical, and what I would recommend as well is we're more than available to contact the panelists directly. All of them will welcome directly contacting you. So I'd just like to first of all thank our panel of experts for presenting to us today, as well as our other colleagues working behind the scenes hard to make this event happen. I think you can all agree there are some great insights there and many, many takeaways, but also some thoughts to take into consideration. Contract risk is certainly an area which is increasing in importance for our tech clients. And with the recent global megatrends, now accelerated significantly by the bigger COVID-related matters, we consider the role, adoption and use of technology to significantly increase in importance. And this would obviously have an overlying influence on contractual risk and some of those complexities we discussed today. Second, on behalf of the Marsh and BCLP team here today, I'd like to thank all of you for joining this session. In these challenging times, we've adapted our approach, which actually has been great. It's enabled us to meet a much wider audience versus our in-person events. And what I will say is we'll certainly be following up next week with a recording of this session, as well as a copy of the slides. Finally, I'm also delighted to announce that we'll be holding a technology M&A webinar next month on Wednesday, the 14th of October. Formal invitations to follow soon. You're all more than welcome to join us. Given the interest levels with today's session, I think we'll be sure to hold much more of these types of events and webinars in the near future. So please stay posted. Thank you and goodbye.